And now I will introduce our Government Affairs Director, Mr. Greg Astorian, to give his updates from California Association of Realtors and some local updates. Greg, go ahead, please.
Thank you very much, President Bunyadi. I appreciate the time. I'll try and be as respectful of your time as possible. So we'll start our presentation very quickly. The topics that we are going to be talking about today involve, and I don't know what, okay. The topics that we are going to be talking about today involves Glendale land use and the housing element. As you know, we are going through it. All communities in California are going through it. This is when they have to show the state of California, the Housing Community Development Department, that they have enough zoning available for the future growth. And each community, each city has got an allocated number. We'll chat about that for a few minutes. The other thing that we are going to be talking about is this redo of split tax split roll tax coming on your to nearest screens next year. We are going to touch on that. We're also going to be talking about the Burbank Parcel Tax and the fate of it, what happened to it, and give you a very small brief about what CAR does in order using the laws in order to enforce a fair and objective development. And with that, we are going to go to Glendale land use element. Now, there is a video on that. We're not going to go through the video because quite honestly, it's 3 minutes and we don't have the time for that, but I'll give you the address for it at the end for you to be able to check it out. As you remember, RENA, or Regional Housing Needs Assessment, these are the numbers of the units that RENA, or the SCAC, or Southern California Governments Association, came up that is necessary for the city of Glendale, about 13,400 units. That number since has changed, has dropped down to 8,229. So about 5,000 less. And the reason for that is because we already have a bunch of projects that are in pipeline and or are being considered for development and so forth. The reason that Glendale got that 8,229 number, not the 13,000, is because, as you know, we are bounded by 3 freeways. So we have a very high connectivity rate as far as highways, 134, 5, and 210. The train, we have the Zarian Transportation Center. Buses, we have the B-Line, and proximity to regional employment, be it JPL, the studios, or what have you. So this is why Glendale has gotten that number of that has to show that we have zoning to be able to provide 8,229 units for the next cycle, in other words, for the next 8 years. Now, I attended Glendale's first public information session on this thing, and they claim that they do not have to, the city does not have to change any kind of zoning, whether it's upzoning or downzoning. And I'll refer to that upzoning a little bit later when we talk about the county side, right? Montrose and La Crescenta. So Glendale thinks that we've always had the enough zoning to be able to accommodate the 8,229 new number for the housing units that we have, to be able to show that we have parcels zoned to provide. They further go and tell us that their development is envisioned in the mixed use areas, mostly in the downtown specific plan and the downtown area. As you know, that is the area that a lot of commercial properties were turned into residential mixed use. By the way, we were ahead of time. As you know, there is an initiative turning commercial into residential. We were way ahead of time on that, even before when the state started to considering it. Right now, the city is preparing a draft. It'll be available November 5th, and it'll be available for you to be able to make comments on it, should you choose to do so. And where you have to go is called GlendalePlan.com. Again, GlendalePlan.com. And you can watch that video that I showed, that I referred to, and a whole slew of other information that may be of interest to you. So that's the land use and the housing element. Let's talk a little bit about the split tax roll that is making its way into a potential ballot initiative. Right now, that language has been submitted to the Attorney General for the approval of the language. Apparently, the people that are behind it are the people from SEIU and a couple of other individuals. It has some very clever provisions to it that would undoubtedly be very, very attractive to renters, because there is a $2,000 tax credit. So if a renter earns $50,000, now owns IRS in the state of California, say $3,000, that renter could get up to $2,000 of direct tax credit. So they've made it palatable for the renter or the tenant population. It also, by the way, increases the amount of the exemption. Right now, it's, I guess, about $7,000 to $10,000 to $200,000. So now they're also targeting single-family home owners that may be enticed to vote for this split tax roll measure in order to be able to take advantage of about $2,000 in savings in the property taxes. This measure targets anything that is over $5 million, and it has a surcharge, by the way. It has a surcharge of 1.2% over and above what you pay for your property taxes. So if your client owns something that is about $5 million and is paying 1.2% today, theoretically, if this thing goes on the initiative, on the ballot and gets voted for, then that client will end up paying twice as much taxes. So you got to be very careful about dissecting this thing. Now, CAR usually gets involved with this stuff once the signature gathering is up to 20 or 25% of the number that is necessary. In this case, it will be about 1 million signatures. That's the number that voted in the last gubernatorial election cycle. So I wanted to update you about this. This is the redo of, again, another attack on Prop 13, except it's a very clever way of approaching it to make it enticing for both the homeowner as well as the tenant. The next thing that I want to talk to you about is Burbank Parcel Tax. Now, if you remember, back in 2018, 2019, this thing was an initiative. It was on the ballot, but it was defeated. It was defeated by about very low margin, about 2.6% or so. But right now, and by the way, this is an explanation of the parcel tax versus property tax. One taxes the use, the other one the value. You need about 66% voter approval or vote people that have voted for it in order for it to take effect. Now we've had that, and this is an attempt in order to actually tax large parcels in Burbank. In 18 and 20, as I explained to you, this measure lost it was on the ballot and lost. So one councilman wanted to bring it back and have another shot at it. And fortunately, it was defeated in Burbank. This was either beginning of October or late September by a vote of 3-1 with one abstention. And that's important. So 3 council members, just like our rep registry, turned around and said explicitly to the staff that we don't want to see this anymore. That's where it's at. And that's good news, by the way, all along, not only for Glendale, but also for Pasadena, because, you know, these things have a way of morphing into larger measures in different cities, especially the neighboring cities. Next thing that I want to talk to you about is a legal action brief that CAR was involved with, along with California for Homes. Occasionally, we do this, especially when we know that the implications, the consequences are enormous. So this legal brief that we filed stemmed from a lawsuit that was brought by California Renters Legal Advocacy and Education against the city of San Mateo. It was about 10 units, folks, 10 small units that were to be condominiums. So the east and the west part of the property were a couple of single-family homes, one with 2-story and the other one with 1-story. NIMBYs and the neighbors got together and said, you know what, we don't want it. Even though the project met all of the zoning regulations, did not need any variance and what have you. And here is where I have to explain to you what Housing Accountability Act is. Because this lawsuit was brought under Housing Accountability Act, that this portion of our Constitution is part of the state law. And what it says is very simply, look, you cannot stop a development because neighbors don't want it if that development has met, to the letter of the law, all of the objective standards of your zoning that you have on the books. And I'm not going to go through the explanation of amicus, but the opinion provided a guide on objective standards that must be used for the purposes of HAA, whether you're going to turn down or approve a development. This was a huge win for the state of California, for CAR, and for realtors en masse, because it is important. And you need to, if you work with clients that want to develop, whether it's 3 units or 4 units or 2 units or 10 units, you need to let them know about this thing. And this, in fact, the court in the case of San Mateo thanked CAR and California for Homes for helpful amicus briefs. It's important to note that the judge decides if they're going to use that amicus brief. In this case, they did. And now we have strengthened the HAA, Housing Accountability Act. It used to this 3 syllables, HAA. It's going to determine a lot of cases in future in the state of California. Now, it gives me a great pleasure to tell you that our own president, Mr. Boniani, is part of or is a member, a director member for California for Homes, which is an arm of CAR, a nonprofit arm of CAR that really sues cities that are not objective on this issue of Housing Affordability Act. So thank you very much, Rick, for all of the work that you've done. With that, if you have any questions, I'll be able to answer. And then I have a very quick update about the LA County Rent Registry. And that concludes my presentation.
Any questions from Greg? Please raise your virtual hand so we can see.
Greg, can I go?
Yeah, Carmen, please, of course.
My question is, with all the information that you shared with us and in respect to City of Glendale, what is our duty or our part in educating our clients? For example, where they're talking about this homestead exemption of $200,000 on properties that are above $5 million. This doesn't sound good to me personally, because I think they're going to get you at the back end. So we need something, a verbiage, something that we could communicate with our clients who are in that category to warn them about it, because if it's put to ballot, people need to be educated about what they're voting on.
Right. And so at this stage, Carmen, this is really a pre-warning. I mean, the document is with Attorney General. Attorney General has to approve the language. We are not there yet. They haven't approved it. Had they approved the language, we would have known about it. Then the process is for them to go out and gather signatures, about 1 million they would need, I believe. Now, here's the problem. There are a couple of initiatives on the ballot for next year that is going to require all of the signature gatherers that work and operate in that space. And that is going to push the price for signature gathering. And that in and itself would discourage a lot of this stuff to go on the ballot or start a signature gathering process. The thinking for CAR is the following, that until and unless such time that we see about at least 20%, 25% of those signatures gathered, we would not get involved. Now, there are exceptions to that. But right now, this is for your information, for our members' information, and you can share as much of it as you wish with your clients, but we do not have a stance or a standing on it yet, because we don't have anything that is publicly available other than what I've shared with you.
Just a quick clarification. The $5 million property, does it have to be residential, SFR, or commercial, or mixed?
Any property that is assessed at $5 million above, including a single family home, right? Okay. Apartments, vacant land, industrial, commercial, street malls, anything that is over 5 million will get, if this thing has its way, will get a surcharge of 1.2% over and above the Prop 13 allowable 1.212%. So it, in effect, doubles the property tax for properties that are over 5 million. Okay.
Thank you.
Thank you. Rick Barnes, you have a question. You have raised your hand.
Yes, Greg. I've been down at the city at 7 in the morning to meet with the planning department and building department people. And it was interesting that on Prop 9 and 10, that the city is saying, well, we're reviewing the information, and at some point in the future, we'll be able to let you know what you can do on property improvement of up to the 10 units, things like that. And it was interesting. Do they have a timeline by the state telling our city that they have to do it within a certain period of time? Or do they just get to put everybody off for another year or two or so on? Do you know that answer?
Yeah, sure. So the answer to that is tune in on city council meeting, the upcoming city council meeting next week, the 26th.
Okay.
That their lobbyists will discuss not only SB 9 and SB 10, but a whole slew of housing. Remember, California Association of Realtors sponsored a bunch of housing bills, especially in the fair housing area. And so they are going to be looking at all of that. Now, you need to know, as a member of Glendale Association of Realtors, that Robert Sandoval has posted a question and answer document that has been prepared by Q&A legal department, by CAR legal department, and it is on our website that answers all of those questions.
It does.
What we have done, yes, it's on the website. What we have done yesterday, as of yesterday, is the following. We went out and got the permission from CAR and provided that Q&A in its totality to your local elected officials, to your council members, and to your mayor. The reason we did that is because there is a lot of competing information out there from those that are against SB 9, those that are against SB 10. And those competing information don't have complete information at all times. We attended on behalf of Glendale Association and Northwest Glendale Homeowner Association meeting about a couple of nights ago, where they had the mayor of Redondo Beach and a lady from what is known, a group that is known as United Neighbors, providing opposing views on, or negative views on SB 9, because these two, the individual from Redondo Beach and the group United Neighbors are against SB 9. Regardless if you are for or against SB 9, that is the law of the state now. Once the governor signed it, it's the law of the state. What does that mean? The city council or the staff of City of Glendale can objectively add, delete, or request provisions to that, right? But they cannot do it in a manner that kills the development scheme under SB 9. But tune in on the 26th and you will hear and understand a lot more, and go to the Q&A that is provided by your association on the website on this very important matter. Thank you.
Okay, another question?
Go ahead.
Do you see an end to this Zoom meetings with the city council? This, and in my mind, the unlawful protection of our city councilman not to be face-to-face with us in person at city council meetings?
Oh, allow me to dodge that question because it'll be entirely improper on my part to say I like or I don't like those meetings. I personally think that Zoom meetings make it very, very efficient if you can have a hybrid scenario.
I can agree with that.
Any other questions from Greg, please?
Mr. Bodiani, may I just give a very quick update on
Sure.
LA County? You know, Montrose and La Crescenta, the part that involves LA County, has also adopted or came up with a draft housing element. In totality, there are 7 parcels. We are under Catherine Barger's district, supervisorial district number 5. In totality, there are 7 parcels that is being recommended for an upzone. And by upzone, I mean to take 22 units to 50 units per acre to about 150 units per acre. And so that's what is going there. There are 7 of those in there. If there is enough interest of any one of you that want to know how this will affect your neighbors and your clients, call me and I'll be able to provide that for you. That's number 1. Number 2, the rent registry that was passed in LA County comes into effect beginning of this year. And if I were to give you a little bit of information on that, that would cost about $90 per unit for units that are prior to 1995 and $30 per unit that are units after 1995. It's called the Just Cause units. You have to register every unit, including your single family home, whether you have a tenant or not. You have to register it. These are the dangers of the rent registry that we so ardently defeated, thanks to you, in the city of Glendale. Thank you, Mr. President. That concludes my brief presentation.
All right, great. Thank you, Greg. Thank you for great information. And thank you, Rick, for asking those questions. I really appreciate this. This is, you remember when I was saying we are small, but we are really mighty. We're everywhere. We're everywhere. And I'm so happy and I'm so grateful for Greg for bringing all this information for us. So now let me talk about the